Good morning, everybody, or I should say afternoon, depending on where you are. Thank you for joining us today. We're looking forward to spending the next hour or so with you all discussing some really interesting topics as we go into summer here. For all of you who do not know me, my name is Roxana Jengi. I am a partner in the Employment and Labor Group in the Calgary office. We have lined up a fantastic panel for you today, each bringing their own unique perspective on workplace issues that we will be discussing. First, please help me welcome Kyle Isherwood, a partner in our employment group in Ontario. Kyle advises Canadian and international employers on a wide range of workplace and litigation matters. He also has broad experience in corporate and securities law. Kyle will be putting on his securities hat this morning, and we'll be going over key employment considerations in M&A transactions. Joining me as well is Catherine Coulter, head of the Employment and Labor Group in our Ottawa office. Catherine has over 30 years of experience and is recognized as one of Canada's leading employment lawyers. Today, Catherine will be presenting on the topic of summer employment challenges, and we'll be talking about issues around vacation, such as quiet vacationing while working in another country, and so forth. She'll also be discussing some workplace trends in these areas. Then rounding out our panel is Emily Crobot. She is an associate in our L&E group in Toronto. Emily advises clients in all aspects of workplace law, including employment agreements, terminations, human rights accommodations, as well as in labor relations. Emily today will be talking about OHS and specifically OHS obligations for outdoor workers. I'm now going to turn it over to Kyle, who will be talking about our first topic. Over to you, Kyle.
Thanks, Roxana. As Roxana mentioned, my name is Kyle Isherwood. I'm a partner in the Labor and Employment Group in Toronto. I did do a little bit of securities law, but now mostly employment. And I do have a specialty in corporate transactions in the employment context. So that's what we're going to be talking about today at a high level, just going through some of the major aspects of corporate transactions and the concerns from an employment perspective and how they kind of impact employees and employment. So we'll start with the next slide, which just has an overview. There's a few different perspectives that I want to cover. The first is going to be buyers versus sellers, and then the second is asset versus share. These have very important impacts on how you view the transaction and what you're looking for to get out of the transaction, and frankly, on what happens with the employees. And then the process, we're going to talk about how the deal is done. We start with the due diligence process, which is kind of the start, and then we move to representations and warranties, which are the contractual provisions in the actual purchase and sale agreement that set out what the business is that you're buying. And then the last thing, we'll just talk on a high level some common issues and pitfalls. So next slide, please. The first of the perspectives that I want to cover is buyer versus seller. Obviously, the goals change dramatically when you're the buyer versus when you're the seller. The buyer is trying to uncover all of the issues that exist with this workplace. You want to know all the bad stuff. You want to know the good stuff too, obviously, but you want to know what the problems are that might impact you later on. And you really need to understand the workforce. You want to know all of the compensation plans, the policies, whether they're compliant with all their ESA obligations, and you want to know the terms of employment for these employees, because you're going to be taking on this workforce after the fact, and there's going to be risks of constructive dismissal if you try and change some of those terms. So you want to know what they are beforehand, so you know, well, can we live with this, keep this as it is? Are we going to have to change this? And what is that going to look like for us in managing those constructive dismissal risks? And then ultimately, at the end of the day, as part of this transaction, you're trying to assign as much of the liability as you can to the seller. And so you're buying pretty much a clean business with as little liability as possible. On the other hand of things, when you're the seller, you're trying to assign as much liability to the buyer. You're trying to be forthright. You want them to know the business that they're going to buy, but you're not necessarily going to overshare. You're going to answer the questions that are asked. You're going to provide the documents that they want, but you're really answering what they want. not going out of your way necessarily. Obviously, there are some big things you don't want to be hiding things, but you're really focused on answering the questions they're asked. And then at a high level, at the seller's perspective, you want the employment to continue on identical terms after the transaction to prevent any sort of blowback that might come back to you as the seller for operating the business prior to the sale. Next slide. And then the other big dichotomy in a purchase and sale is whether it's asset versus sale or versus share. And to put it frankly, that's not going to be, it has a huge impact on employment, but it's not decided by employment. Nobody's deciding how to structure their transaction based on whether the impact it'll have on employment and the employees. That's generally decided by tax, but at a high level, if there's a share purchase, there's no impact on the employees. The company remains the same, the company's still employing them, the owner of the company changes. If it's an asset purchase, you're technically buying just the assets. If the employee continues, or if the employee transfers, that's technically a termination of employment. There's sections of the ESA which deem it continuous, but from a common law perspective, it's a termination of employment. Next slide. So from a share transaction, as I mentioned, it's continuous. In general, you're accepting the workforce as it is, warts and all. The existing employment agreements, policies, procedures all remain enforced unless you take active steps to supersede them. And then in which case, because employment is continuous, you need to talk about fresh consideration for those new employment agreements and changing terms. The existing liabilities all remain with the buyer. So any outstanding are all transferred to the buyer as the new owner of the company. They remain with the company. So all outstanding litigation and complaints, all termination entitlements, all WSIB claims, all MOL investigations, everything just stays with the company. And if you want to assign some of the liability or the costs related to that, you have to deal with it in the purchase agreement itself. And then we'll contrast that with the next slide, which is the asset purchase slide. And in that case, you're purchasing just the assets of the business. No employees will automatically continue with the buyer. If you want to continue employees, you can offer them employment. But because there's no obligation to offer employment, there's no obligation for consideration for those new terms. That said, it will be a contentious point in negotiation because the seller will want the terms to be identical so that they don't have any risk of terminating these employees. And the buyer will want the best terms, the terms that they want. And so there's always it's going to be part of the negotiation on what happens with those terms. In general, in an asset purchase, the liabilities remain with the seller. But as I said, if the employees are hired by the buyer, there are provisions of the Employment Standards Act in all the provinces that deem that employment continuous. So even though it's an asset purchase, the employment is deemed continuous if the employee transfers over. So you have to recognize all that service, vacation pay, all those sorts of things. And then you can still assign liability through the purchase agreement, and you might still want to do that to address any particular concerns. So we'll move on now to the process on the next slide. And so first we'll talk about due diligence. And I mean, this is, I say it's an actual physical process. I mean, it used to be physical. You used to have to go into a boardroom at usually the lawyer of the seller side and look at all the documents. Now it's all done virtually pretty much. It all goes into a data room. And you're the seller, you're uploading all these documents to the data room. The buyer, you have access, you can review all those documents. And you're reviewing everything you can about the business. Employment is just one part of this due diligence process. From an employment perspective, we're usually looking at employment agreements, the employee census, policies, procedures, any outstanding litigation, complaints, what happened with terminated employees, WSIB claims, ML investigations. You want to know, as I said, everything so you know the warts of the business. And then as a seller, you're answering the questions, you're providing the documents that are requested. But every due diligence is different and no two companies are the same. There's never going to be a perfect, I haven't come across a perfect company yet with no issues. So the red flag, ultimately at the end of the due diligence process, you're creating a red flag report, which sets out all the issues that we've spotted from a legal perspective with the business. And I've never had one of those come back where it's been, this is empty, this is a great business, no employment concerns. There are various degrees, but there's always something. Next slide. And then so you finish the due diligence process. That informs the representations and the warranties in the purchase agreement itself. So you take what you found in the due diligence process and you kind of contractually move it into the agreement. So the representations and warranties is the formalized contractual representation by the seller, primarily from an employment perspective. We're really just talking about the seller's representations to the buyer. And it's a formalized contractual representation of like what the business is. So you're going to have an employee census. These are all the employees. Like contractually, you're saying these are all the employees that this business has. These are their terms of employment. Whether there's a union involved, you'll have a clause that says that they've complied with all employment standards laws. So that includes vacation pay, overtime, termination pay, severance pay, human rights laws. Usually there's now more often than not terms about no sexual harassment or sexual harassment claims with the business. And so it's very broad. And from the seller or the buyer's perspective, you want it as broad as possible. You want to cover as many potential risks and liabilities because they're representing that these don't exist, and then you want that to be as broad as possible. All the issues they're representing and warranting that there are no issues with the business. Obviously, on the seller side, you want to disclose issues that you have, so that it's not going to be part of this representation and warranty that you've now given that these are all clean. This is a clean business. So that part of it is there's a disclosure schedule. This is getting a bit into the nitty-gritty, but as part of the representations and warranties, for certain things, if there are issues or you're just disclosing items, it will say except as disclosed in disclosure schedule. And the disclosure schedule will set all the things that you want to say, like you can say, for instance, a good example might be helpful. You might say there are no collective agreements with respect to these employees. Well, in the disclosure schedule, if there are ones, you'll say except as disclosed, and then you'll include the collective agreements in that. And so you're just kind of like setting out what exactly this business is and what issues and the status of business is contractually, so that the employee, like the seller, or sorry, the seller is representing to the buyer that these are the issues, and if it's wrong, the buyer can come back and rely upon that agreement and potentially seek damages. And next slide. There are a couple other purchase and sale agreement terms that come up pretty frequently in these situations. One is with respect to assigning liability. So typically what will happen in the agreement is they'll assign liability pre-closing. So they'll make the seller liable for all employment issues that occurred before the transaction, and then they'll make the buyer liable for all issues that occur after the transaction. As I mentioned, because in an asset sale, you're not actually buying the business, you're just buying the pieces of the business. This occurs at law, but you still might want to have certain things specifically called out as the seller's liabilities. And if employment is continuing, you might still want to assign liability through that because the ESA deems those employment relationships continuous. And then the other thing that comes up in these purchase and sale transactions is offers of employment. So this is essential in an asset purchase, whether the employees will be continuing, and the terms of that employment is set out usually in the purchase agreement. They'll usually set out exactly which employees will be continuing, which ones will not be continuing, and you'll provide a high level overview of what the employment contract will say. Obviously, the seller will want identical terms because otherwise they could be liable for constructive dismissal if the employee never refuses to accept that new employment. And the buyer will want their new terms of employment so that the employees are on the same agreements as everyone else at the company. And then just at a high level, any employee that's terminated as part of closing will be the seller's liability. So that's why the seller wants the terms to be identical, because then they can say, well, you should have taken that employment position with the buyer. And then we'll go to our last slide, which just briefly touches on some pitfalls. I mean, a lot of this is rushing through the transaction. So oftentimes what I've seen is that a seller realizes that they're going to sell, and they suddenly try and fix everything. So they'll put new employment contracts in place. They'll try and tighten up their policies and everything. You can see when things were changed because of dates of the employment contracts and everything. And I mean, it's great to update your processes and make things correct in advance of a sale. But when you try and do it too fast or you do it too close to the transaction, oftentimes it can result in duplicating work because the buyer might want their own agreements in place anyway. So you've now fixed it, and then the buyer's going to try and fix it after the fact. So it's kind of a continuum. Like the closer you get to a transaction, sometimes it makes sense to like coordinate with the buyer how you want to fix some of these issues rather than trying to fix it yourself, realizing that it wasn't necessarily good enough and fixing it again, or it wasn't what the buyer preferred. The other problem that we see oftentimes is putting new employment agreements as part of a share transaction. Employment is deemed continuous in those transactions. So if you just put a new employment contract in front of someone just because there's now been a purchase and sale, that's not going to be enforceable unless you give them fresh consideration. Just have continuing to work through that share transaction isn't going to be enough. The other issue is just skipping due diligence or not putting enough emphasis on it. There are big issues that can come up in due diligence. Obviously, not everything's the same. Sometimes you have like a fatality, an MML investigation. That's one end of the spectrum, but there's a whole range of things that can come up, and you don't want to miss some of those issues and then be caught in an investigation after the fact. And then one last thing I'm going to touch on today is just thinking about integration. Lots of companies just do the purchase and sale and they just don't think about what's going to happen after the fact. But like think about how are the bonus plans going to align between the two companies? What are the benefits? How's the benefits going to work? Are you going to transfer them over to new benefits? Are they going to continue on their old benefits? Does their salary grid match with your salary grid? All those sorts of things. And then redundancies too. Like, are now you going to have two people doing the same job? But you have to think about all those things. It's often a post-closing thing, but it is important to do it during the transaction too, so you kind of know what you're going in eyes wide open to the actual transaction itself. And with that, I will turn it back to Roxana or Catherine.
Thanks,
I'll
Kyle.
hand it over.
Thanks, Roxana. Good afternoon, everyone. Pleased to be here. We finally got summer, right? This is exciting. We had the longest day of the year last week, and of course, last week's extreme heat in Eastern Ontario. With summer comes summer vacations. Most of you likely have employees that are going to be taking some time off in the next 2 months. And with that, what I want to do is take you through our primer on summer vacation issues, including fun things like vacation carryovers and a concept that I actually didn't really know had a name, but it does, called quiet vacationing. And I've also got some fun facts in my webinar presentation. They're meant to keep you all awake during the presentation. So, presentation is focused on Ontario law, as that's where I practice. Keep in mind that each province is substantially similar when it comes to vacation obligations, but they're not identical. So, before I get into the fun stuff, it's important to have a refresher on vacation law in Canada. The reality is that, as I see it in my practice, even the largest and most sophisticated employers often don't get it quite right. It's a very complex area. And so with that, can I have the first slide, please? First of all, I wanted to be clear that in Canada, unlike in many other countries, including the US, there's a distinction between vacation time and vacation pay. They're different things. They usually work together, but they don't have to. But both components need to be honored. Let me back up a bit. Each province has minimum vacation time and vacation pay requirements under whatever the applicable employment standards legislation is. If you're in Saskatchewan or if you're a federally regulated employer under the Canada Labour Code, both of those jurisdictions recognize the right to 4 weeks of paid vacation after a certain period of time. But for the rest of Canada, they're all aligned, and they recognize two things: a right to 2 weeks of vacation time for employees with up to 5 years of service, with a vacation pay component paid out at 4% of wages, and then secondarily 3 weeks of vacation time for employees with 5 or more years of service, with a vacation pay component paid out at 6% of wages. And I use the term wages because it has a specific meaning under most of the legislation. Wages is really important because in most jurisdictions, it's a term that includes not just your base salary, but your commissions and your incentive bonuses. In other words, if you're an employer and you are paying your employees things like commissions or incentive bonuses or even profit sharing, you're supposed to be adding that 4% vacation pay or 6% vacation pay amount to those payments, not just on top of the base salary. Let me back up again a bit. Most employers continue to pay their employees while they take vacation time, right? Somebody goes off on vacation, they just continue to get a paid paycheck. And if that employee is just entitled to base salary, they don't earn commissions or incentive bonuses. Let's say that employee is entitled to 2 weeks of vacation time under the legislation because they've got less than 5 years of service. When you continue to pay them during their vacation, that's actually going to work out to the 4% of base salary that their vacation pay is supposed to be. That's not coincidental. That's their vacation pay entitlements under the legislation. And if you do the same thing for an employee that is entitled statutorily to 3 weeks of vacation time, you continue to pay them during their vacation, and they're only entitled to base salary, you're going to find out that that amount that you pay them while they're off for 3 weeks is going to equal 6% of their base salary. So again, you've covered off their entitlement under the legislation. We all good so far? If you just continue to pay your employees their base salary while they take vacation time, but they also earn commissions or incentive bonuses or profit sharing, they're going to end up shortchanged if they don't receive and take more vacation time than their statutory minimum entitlements, or if you don't add vacation pay to their commission or incentive bonus payments. And so as a result, for employees who receive wages that are in excess of base salary, you're going to need to either add 4% or 6% vacation pay to those extra payments, or you're going to need to do a year-end annual reconciliation in order to make sure that all statutory vacation pay has been paid. And so that takes me to this tip number 1, or takeaway number 1. If you don't currently add statutory 4% or 6% vacation pay to your commission or incentive bonus payments to employees, you probably have a vacation pay liability. And remember, it's not just a corporate liability, it's also a director liability. So it's very important to stay on top of that. Can I have the next slide, please? First fun fact, only roughly a third of Canadian employees used all of their vacation time in 2022. Interesting. That may mean that there's a lot of vacation pay liability hanging around out there. Can I have the next slide, please? A majority of Canadian employers actually provide more paid vacation than the statutory requirements, and we're going to see that in one of my next fun fact slides. This includes US companies that like to provide what's called unlimited paid time off, or PTO. And that's fine, you can absolutely do that. And you can also treat the non-statutory vacation differently than you treat the statutory vacation. But if you are providing more vacation time and vacation pay to your employees than the legislation requires, you're going to want to carefully track it so that you know whether or not all statutory vacation time has been taken and all statutory vacation pay has been paid. Doing a year-end reconciliation is a really good practice if your company gives more vacation each year than the legislation mandates. It's going to help you reduce your vacation pay liabilities if your employees are actually taking that extra time in excess of their statutory entitlement, and if they're also receiving commissions or incentive bonuses, because you can essentially do a set-off in that practice. But that only works if you do a reconciliation process at year-end. And so that takes us to our tip number 2, our takeaway number 2, which is to carefully track the vacation time your employees take and the vacation pay which they're paid. I know a lot of US-based employers don't do that. It's critically important in Canada. You can't possibly know whether or not your employees are properly taking their statutory vacation time and getting paid all of their statutory vacation pay unless you're tracking it. Be particularly careful to do this as well if you grant this extra unlimited paid time off or excess paid time off. more vacation than statutorily granted. You're going to need to be tracking the excess as compared to the statutory. Can I have the next slide, please? So, another fun fact. I didn't know this. Globally speaking, and this is a global statistic, not a Canadian statistic, Generation Z workers, by 3/4 roughly, are most likely to say that they don't get enough vacation. They have pretty high vacation expectations. They're followed by millennials at 66%, and I can attest to that, and the Generation Z, having kids in those age ranges. Then you've got Generation X at 58% and baby boomers. Baby boomers are pretty happy with the amount of vacation that they get. It may partly be a reflection on the fact that they're older and they have more excess vacation that's granted to them by their companies just in terms of length of service. Can I have the next slide, please? We're going to talk about other vacation considerations now. This is the fun stuff, right? The other stuff was the meat of it all to put this into context. And the first topic is vacation carryovers. So you're going to want to make sure that you're clear in an employment agreement, as I say, or in a vacation policy as to what vacation carries forward if it's unused and what vacation is forfeited. The main thing that you need to keep in mind, always, and it's, you know what, of all the takeaways that you could actually take away today, this is probably the key one, the most important one. It doesn't matter what province your employees are in. You can never have a use it or lose it policy when it comes to the statutory vacation time and statutory vacation pay. Ontario in particular is very strict. In Ontario, your statutory vacation time is supposed to be fully taken each year, and that's on the employer. The employer is supposed to be monitoring it. I always tell my clients, you know what? Do a quick review of the workforce every year when everybody comes back from the summer holidays at the beginning of September and see where everyone's at. And if you've got people with big chunks of statutory vacation that they haven't taken for the year, tell them you've got to take it between now and X date. And if you don't, we're going to mandate that you take it. We're just going to send you out whether or not those dates work for you. You've got that right under the legislation. And that's there on purpose so that employers in Ontario don't end up with non-compliance to the legislation. But if it's not taken, it's got to carry forward. Again, we're talking about the statutory component here. Statistically speaking, in Ontario, you're not supposed to pay out statutory vacation if it hasn't been used. Instead, it gets carried forward indefinitely until it's used or until the employee leaves the company. And when they leave, you have to pay out that statutory vacation pay. Excuse me for just a moment. Thank you. In some other provinces, it's a little bit easier to pay out statutory vacation prior to the termination or resignation of an employee if they haven't used all of their vacation. This prevents carryovers and it prevents accruals of large vacation pay amounts on the books. And so that's a good idea to do if you have employees in provinces where that's allowed. Whatever the case, and I have some employers that do mandatory payouts if employees aren't taking all of their vacation in Ontario, even though you're not supposed to do it that way, because they want to get that vacation pay liability off the books. Whatever way you do it, the employee has the legal right to their statutory vacation time and their vacation pay, and the company can never, ever, ever do away with that right. On the other hand, the non-statutory vacation, so that excess that you've granted them under a PTO policy or something else, that can be handled however you want to handle it. You have to put it in writing. It has to be clear to the employees, but you can do what you want. So for example, if you've got an employee with 3 years of service and they've been granted 4 weeks of vacation per year, they're only entitled to 2 weeks of statutory vacation time. You have to make sure that they take that statutory 2 weeks of vacation time and that they receive their 4% of wages for vacation pay. But you can have a term in the policy or the agreement that says that if they don't use the excess vacation time, it's forfeited at the end of the year and there's no payout on that excess vacation pay. You're entitled to do that. You just have to do it clearly. So the key, as always, is to have something clearly stated in writing. And one of the best ways for companies to reduce their vacation pay liabilities and their both their corporate and director vacation pay liabilities, is to ensure that non-statutory vacation is forfeited each year if not used, and it's been clearly set out in your policy. Can I have the next slide, please? Another fun fact, the time off tax. I didn't know about this. It means the amount of extra time worked by employees before going on vacation so that they can get away. In 2023, that average amount was 18 hours. Think about that. And you can probably put it into context for yourselves as well, because this applies to everybody on this call and not just the employees that you're managing. You know what it's like, right? You're going on vacation. It's a mad dash. You're working day and night and weekends before you go, just so that you can go away. Sort of gets around the relaxation part of vacation a little bit. Just something to think about. I thought it was interesting. Can I have the next slide, please? Quiet vacationing. This is another term which I didn't know existed. I knew about the concept, didn't know about the term. It's a fairly new concept, which has arisen largely since the pandemic, and it means taking time off while still working. So in other words, employees appear to be working a full-time job, but at the same time that they're actually taking time off and they're not clocking the time off. This US poll by Harris Poll last year showed that over a third of US millennials engage in quiet vacationing as they want to take time off, but they're actually worried that doing so is going to impact their career trajectory. Again, something to be aware of as you're managing your workforce, particularly if you have a group of younger employees working for you. Next slide, please. Another fun fact. So I told you I'd get to this, the number of vacation days for Canadian employees in general. This is an average, of course, but for Canadian employees with a year of service, the average is actually 16 days. So a day more than 3 weeks, and remember, 3 weeks is typically what one is required to give statutorily with 5 or more years of service. Most employees give that extra week and a bit right off the top. And that increases over time all the way up to an average of 25 days at a cap for long-term employees. The other thing to keep in mind is, although most vacation legislation contemplates accrual of vacation, so you start and you accrue on a monthly basis until you've accrued your first 2 weeks of vacation as a new employee, 3/4 of Canadian employers just give the entire grant immediately upon hire. And that seems fair and reasonable, but you need to think about different ways of managing that in particular, particularly if the employee wants to take all of their vacation right off the get-go, before they've done a lot of work, before they've even completed probation, for instance, or what to do if that short-term employee comes in, takes all their vacation, and then leaves, having taken their vacation, because it can be hard to get it back and difficult under legislation to claw it back. Just a fun fact. So, next slide, please. A similar practice to the quiet vacationing that I just talked about is known as hush trips, working from another country while on vacation without actually telling your employer that you're on vacation. I'm going to talk about that briefly right now. So, many employers permit their employees to do some work while on vacation. If the employee is vacationing in Canada and it's just a vacation and not a move, that's going to be fine. If they're vacationing in another country, it can be an issue. Not necessarily, but it can be. First of all, sometimes employers don't even know that their employees are on vacation in another country, as they appear to be working because they're doing that quiet vacationing. And here's the problem with that. Most employees don't actually turn their mind when they go on vacation to another country that they're only permitted entry on a tourist visa, not on a work visa. And in some countries, if you're working while in another country and you've declared yourself for tourist visa purposes, that can lead to being refused entry into the country if you're going to work, or being removed from the country if you're found to be working. Every country is different. Some countries have digital nomad visas, which permit people to enter the country to work without a special work permit or special visa, and also to vacation. Examples include Italy, Portugal, Thailand. There are a whole slew of them now that have cropped up since the pandemic. Canada's got something that's not a digital nomad visa, but foreign Remote workers can enter Canada on vacation and can work for foreign companies for a period of time while vacationing. But other countries don't permit it at all. And that can lead to some of the issues that I've listed here: immigration and work visa issues, loss of out-of-country benefits coverage, corporate tax issues for the employer, potentially, and securing confidential information. Just keep that in mind. Slide, please. Next slide, please. Last fun fact, I think, Canadian employees tend to use 17 out of 19 vacation days per year. So they try to take most of what they get. Next slide, please. Vacation during protected leaves of absence. I get asked a lot about what happens to vacation when an employee is on a statutory leave of absence. Those are things like pregnancy and maternity leave, parental leave, critical illness leave. There are a whole slew of leaves. I'll also include disability leaves here, although not every province has serious illness or disability leaves under employment standards legislation. You can't discriminate under human rights legislation, so I like to treat it the same. Technically, you can't take someone's vacation entitlements away while they're on a leave of absence. So that means that their statutory vacation time continues to accrue. That's not necessarily the case for vacation pay, though. And that's because vacation pay is a percentage of wages. Okay, so as I've said here, if an employee's on leave and they're just collecting EI from Service Canada or disability benefits from an insurer, then 4% or 6% of $0 from the employer is going to equal $0 in vacation pay. If you're doing an EI top-up or you have company-funded short-term disability, then those amounts are considered wages and you're going to have to pay your 4% or 6% vacation pay on those particular payments, but not on the EI or not on the EI component. So all of this can be really difficult for employees to understand. They just assume that their vacation pay continues to accrue while they're away. So it's a good idea to set this out in your policy as well. I've gone over my time. I'm happy to answer questions at the end. But in closing, I've found that vacation time and vacation pay are one of the issues that cause employers the most problems and they're the most difficult to understand. Having a good policy in place is a great place to start. And if you have any questions, any member of our team would be happy to assist. Thank you.
Hello, everyone. I'm going to take it from here and move on to our last topic of the webinar today, which is heat-related occupational health and safety obligations for outdoor workers. And certainly with the recent heat wave we've had, this is definitely a topical topic. So moving on to the next slide. So each of the provinces operates a little bit differently with respect to all occupational health and safety laws because we don't have occupational health and safety laws at a national level. It's up to each of the provinces to set the standards that they would like to see in each of the provinces. And then, of course, federally regulated workplaces abide by Part 2 of the Canada Labour Code with respect to occupational health and safety laws specifically. So under this umbrella of occupational health and safety laws, you will find heat stress. And as I mentioned, every province operates a little bit differently. Some of the more detailed requirements you'll find in provinces and territories like British Columbia, Quebec, and Yukon Territory. And some of the less detailed requirements you'll find in Prince Edward Island, Manitoba, and Nova Scotia. However, there are some common threads between each of the provinces that you'll find. So for example, most provinces and territories require compliance with the ACGIH's 2019 threshold limit values for certain chemical substance exposure and physical agents, including heat in this case. And then many of the provinces also have published guidance documents with respect to heat stress and thermal temperatures. And finally, in each of the provinces, all employers have kind of a general duty to protect workers. So that's a very, very broad umbrella obligation that includes any sort of threats or potential threats to workers, which would also include heat exposure in this case. The provinces also have regulations and guidance documents with respect to heat or cold stress rather, but perhaps we'll expand on that in a winter webinar. Moving to the next slide, please. So we're going to start off, we're going to move west to east today. We're not going to cover all of the provinces simply because we don't have time for that, but we're going to start off with British Columbia. So if relevant to you, the relevant sections of the BC Occupational Health and Safety Regulation are 7.27 to 7.32 of Part 7. But to give you a high-level overview of what's required in British Columbia, these specific heat stress regulations apply to workplace if a worker is or may be exposed to thermal conditions which could cause heat stress. The thermal conditions could result in a worker's core body temperature exceeding 38 degrees Celsius or 100 degrees Fahrenheit for any Americans tuning in, or the thermal conditions are in excess of the levels listed in the screening criteria for that ACG-IH standard that I mentioned earlier. This standard is published by a nonprofit organization that does research into and sets standards for different areas of occupational health and safety law, and it's not uncommon to see these sort of external standards baked into legislation, whether with respect to heat stress or other areas as well. Next slide. So BC published some examples of where these heat stress regulations may apply. These are just some specific examples. This is not an exhaustive list. But wherever a worker would likely be around really hot equipment, so you can see pulp mills and sawmills, smelters, kilns, anything where they're kind of enclosed in a space where it can get really, really hot. And then also outdoor work sites during hot weather. So we've all seen the road construction, particularly in downtown Toronto, for example, but anywhere where it's outside and the work just so happens to be in a very hot time and place. Next slide. So the OHS regulation in BC also mandates the use of specific personal protective equipment. So for example, cooling vests or cooling jackets, and requires the implementation of a heat stress assessment control plan, which would, look at potential risks, acceptable responses to those risks, acceptable measures and methods and controls, as well as the provision of water removal from of a worker from a work site if required, and any first aid treatment in the event of overexposure to the heat. Next slide. So moving on our westward, or rather eastward journey to Alberta. So conversely to BC, in Alberta, there are no regulations that specifically address heat stress. However, Alberta employers must ensure the health and safety of workers at their worksite pursuant to Section 3.1 of the Alberta Occupational Health and Safety Act. So that's kind of that broad overall duty clause that I mentioned earlier. In addition to that, the Health and Safety Code in Alberta provides that employers have to do a hazard assessment, which includes assessing a work site and identifying existing and potential hazards before work begins at the site or prior to the construction of a new work site. And although heat stress isn't specifically mentioned here, it's not specifically mentioned in the general duty clause. If the heat could be a potential hazard or endanger workers in any way, then employers are expected to consider that and then act in a way that helps mitigate against that risk. So, I mean, there's, I think, upsides and downsides to having very, very detailed obligations like we see in BC, where there's certain standards that have to be met, and then having more of a vacuum with respect to what is expected, like we see in Alberta. However, if we look at the next slide, what we do find in Alberta is guidance documents. And although these guidance documents are not law, typically what we say is, as an inspector, if an inspector is coming into your workplace, they're going to be informed by one, yes, the black letter of the law, but two, any published guidance documents by the respective province. So it is good to pay attention to these guidance documents, even if they don't have the full force of the law. So in Alberta, the government has suggested that employers use a work rest schedule. You can change a work location to a cooler shaded area. Now that's not always practical if the workstation happens to be a construction site on a given road and there's no shade nearby. But there are other things that you can do. For example, creating a cooling station that allows workers to rest, giving workers some time to adapt to the temperature, so kind of increasing exposure over time. Scheduling more physically demanding jobs for a very early morning or evening to avoid performing work in the sunshine, which can, obviously impact the heat. Providing plenty of cool drinking water, maybe even electrolytes, Gatorade, that type of thing. And performing a hazard assessment. So putting controls in place for protection, as well as educating workers on the hazards of working in heat so that they can recognize those risks if they start to display them and act accordingly. Next slide. So in Ontario, while there isn't an official act or regulation yet, what we have done is in response to a call for feedback actually that the government put out in 2022 or 2023. The government has drafted Bill 222, which is the Heat Stress Act 2024. And in the preamble, the stated goal of the act is to increase worker protections in response to climate change. So obviously, as the climate is changing, we are seeing more extreme temperatures, including hot temperatures, which, as I mentioned previously, anyone walking in downtown Toronto this week will appreciate. Next slide. So if this bill is passed, and I believe it's only in its second reading now, if that, so we will have some time before this bill is officially passed, if it is. Essentially, the idea is to have a worker heat protection standard in place. So instead of having this general duty and guidance document, which I'll talk about in a moment, this would be fleshing out what exactly the expectations are for employers with respect to having employees working in the heat and protecting those employees. So just a high-level overview. There's a lot that would go into it, but the focus is on eliminating hazardous levels of heat through different controls. So for example, you can see, you can isolate employees from sources of heat, you can insulate hot surfaces, you can use air conditioning. There's many different things that you can do. Of course, limiting exposure, providing breaks, personal protective equipment, developing policies, providing training on those policies. Really, this would just be fleshing out what's expected of employers. Next slide. However, for now, essentially what we have is the general duty clause. So taking every practical step to protect employees at the workplace. And then we also have one section of the industrial establishments recommendation that does set a temperature for work that's performed indoors, but it is a floor and there is no ceiling. So not a ton of guidance, official guidance in the regulations to work with in Ontario, but I'll take us over to the next slide. We do have a guidance document. So as I mentioned earlier, it is best practice to follow published government guidance documents because they do inform the perspectives and the enforcement actions and possible orders of inspectors at the workplace. So this guidance document suggests designing your workplace to reduce heat stress by improving insulation, adding in barriers or air conditioning, planning ahead. So we're seeing those rest breaks, scheduling, cool drinking water. A lot of the guidance is repetitive and is fairly consistent across the provinces, allowing workers to adjust to hot environments, as we saw again, encouraging workers, or even better, mandating workers to wear protective clothing, particularly clothing that's reflective, light, breathable, and then creating a plan for those days where it's just too hot to work, or there need to be certain things put in place to make it safe for workers to perform work in the heat. Next slide. Okay, and we're finishing off with Quebec. So as I mentioned earlier, Quebec has more stringent heat stress regulations, and all of these regulations, they're not in a guidance, or all the guidance is not in a guidance document, it's in the regulation itself, so it does carry the letter of the law. So pursuant to an employer's general obligation to protect a worker's health and safety, and as well as the specific regulations set out in the Quebec regulation respecting occupational health and safety, employers need to take specific steps to avoid heat stress in generally hot workplaces and in all workplaces during hot days. So these regulations are applicable to any workplace with over 50 workers where workers are exposed to heat stress. And employers must ensure workers undergo medical supervision and provide them with water at a temperature of between 10 degrees Celsius and 15 degrees Celsius, and also provide at least one shower per 15 workers. So this is very, very specific legislation. It also sets out that employers must add insulation or ventilation to reduce heat stress or implement a work rest schedule. Next slide. And then in addition to those regulations, the CNE-SST has a heat stress guidance document, which is very, very consistent with the other guidance that we've seen. So in order to give us enough time to answer some of your questions, which I understand we have, I will wrap up there. But thanks very much for your attention.
So I think we've got some questions here in the Q&A. I am happy to answer them. They're all vacation questions, but I don't want to take up all the spotlight on my friends. So Roxana, if you want to jump in at some point and toss questions to somebody else, that's perfectly fine. One of the questions is, if an employer moves to an unlimited vacation policy, are they still required to honor any vacation, any vacation under employment agreements that exceeds the statutory minimum? I think what the question is asking, if I understand it correctly, is, quite apart from statutory vacation, an employment agreement with an employee may well give the employee an extra 2 weeks of vacation per year. What happens if the company moves to an unlimited vacation policy, or a PTO policy, as they're often called? Are they still required to honor that, extra 2 weeks per year under the employment agreement? Complicated. We'd probably have to talk a little bit more. Generally speaking, they should be able to just adhere to the policy because the policy is a greater benefit. The question is, what are you doing in your policy in terms of that unlimited PTO at the end of each year? Is everything that's non-statutory falling away? And did you, under your prior employment agreements, have a policy under which the employee was allowed to carry forward that excess vacation that wasn't taken and have it paid out, or have it continue to be accruing and owed to them? So it really becomes a question of, are you moving to a better benefit, the same benefit, or a worse benefit? And depending on the answer to that, I think that's going to dictate ultimately what happens. I believe that Roxana, our host, is having troubles with her mic, and so I'm just going to keep going here. I hope nobody minds. Another question is, while an employee is on job protected leave, if the employment agreement offers more than statutory vacation time, would the employer still be obligated to carry forward vacation leaves based on what's there in the agreement, or decide to only extend based on applicable statutory entitlement? So if you offer an employee something in a policy or an employment agreement, whether it's vacation or something else, that is a better benefit than the legislation, then that becomes your threshold as a matter of law. then that's what the Ministry of Labor and the courts are going to adhere to going forward, in terms of what the employee is entitled to. You can't then default back to the legislation without changing that employment agreement or that policy. That can be done. Policies are easier to change than agreements. You need to provide consideration generally to change employment agreements and terms in employment agreements if they are fundamental terms or terms of value to the employee. But a policy is generally intended to be a living document that is subject to change from time to time. You might need to give your employees, some degree of notice, perhaps 8 weeks of statutory notice, which tends to be the statutory cap unless there's a mass situation, unless there are a lot of employees. But generally speaking, if you give your employees 8 weeks of notice that the vacation policy is changing, you might get some blowback, but you're not going to end up in trouble, in legal trouble. And so the answer to that particular question is, you may be able to make the change. It depends on what's actually happening behind the scenes and what the employees are giving up or not giving up and whether or not there's a better benefit. With that, we've got 2 minutes left. I will take it upon myself to wrap up on behalf of our entire team. I want to thank everybody today for joining us. We will be picking up with these national webinars again in September. On behalf of all of us, again, thank you very much.